Thank you all for being here for what I think is a very important night and talking about a very important subject in the history of Kansas City, the history of civil rights in Kansas City, but also the history of civil rights in the United States. I do want to mention very quickly, before we bring out our distinguished moderator and our distinguished panel, three upcoming programs that I think this audience will particularly be interested in. We have a series of conversations with entrepreneurs we call Kansas City Cradle of Entrepreneurs, and we're shifting to a sort of sub-series of that with entrepreneurs in the not-for-profit sector. And the first one we're going to do is next Thursday, March 3rd, here at the Plaza Library with Sue Ellen Freed. Many of you will know Sue Ellen, who has created with Blanche Sosland a national organization to deal with bullying. She's created Reaching Out From Within with doing education with prisoners in our regional prisons, and created a foundation for child abuse that has been a model for the nation. And I think our conversation with her will be very enlightening on a number of important subjects. On Tuesday, March 8th, also here at the Plaza, two of the most interesting African Americans to be born and raised in our region, going on to fame in the larger world, Langston Hughes and Gordon Parks, worked together on Langston Hughes' book, Shakespeare in Harlem, and the photographs thereof. And Arnold Rampersad, the very distinguished prize-winning biographer of Langston Hughes, Jackie Robinson, and Ralph Ellison, will be here to talk about that in association with the Nelson's show of African-American photographers. And last but not least, if you read the New York Times regularly, you'll have read earlier this week an extraordinary review of an extraordinary book, Evicted, by Harvard professor Matthew Desmond, which is about people being evicted from housing in the millions now in the United States and its relationship to poverty. It's an extraordinary book. So those three programs are coming up in the next 10 days at the library. Tonight I'm here to introduce Steve Kraske, and I think probably everyone in this audience knows Steve Kraske, literally a man who needs no introduction, but longtime political reporter at the Kansas City Star. He runs one of the great not talking head because you can't see the heads, but talking mouth programs on radio in this country, in KCUR. We bring lots of authors in, as you know, to the library, and many of them make it to Steve's show, and they all come back and they say, here's a guy who knows what he's talking about, asks great questions, and is a great host of a great show. And today he is also moved, no longer writes for the Star regularly, but has moved to UMKC, where he is a professor of medieval history. Oh, sorry, journalism. A professor of journalism. So, ladies and gentlemen, a real star in Kansas City's firmament, Steve Kraske.
Well, welcome to Up to Date. I'm Steve Kraske. So nice to have you all here tonight to take part in this very important conversation about a part of our history that's sort of long forgotten, but certainly made a mark on the long road to racial equality in our town. It's a story about the desegregation of the Swope Park pool and the Swope Park swimming pool. Public pools were the lesser-known cousins of schools back in those days, lesser-known cousins of lunch counters, where the battles over equal rights played out a whole lot more prominently. But I think tonight you're going to hear something different, something about how significant swimming pools were to the early civil rights debate. Before we get to our distinguished guests, and they are very distinguished, please watch and listen with me to a short presentation of voices and images to help set the scene for tonight's event. This was put together by my KCUR colleague, Laura Ziegler.
I'm Howard Sachs. I'm a federal judge, federal district judge, a senior now, 90 years old, and 65 years ago, almost, I was a law clerk for Judge Albert Ridge of the federal court, who decided the swimming pool case. It was a federal judge, federal district judge, senior now, 90 years old, and 65 years ago, almost, I was a law clerk for Judge Albert Ridge of the federal court, who decided the swimming pool case. It was a curiosity. They chose as the first named plaintiff Esther Williams, who was a movie star at the time and particularly a swimmer. I always thought that plaintiffs' lawyers were sort of amused to put her name first. Thurgood Marshall had quite a sense of humor, so I wouldn't be surprised if he hadn't said, well, let's have her first name plaintiff.
Okay, my name is Clarence Shirley. I was born in Kansas City in 1933, August the 5th. I was a lifeguard and I worked at Paseo swimming pool for a summer job.
My name is Rhonda Smith. We live at 1310 Highland. Every summer, we had the opportunity to go to the Paseo Park pool. We had to get there early because it got real crowded.
What it felt like to be a lifeguard here is we had a very small pool compared to Swope Park pool.
I didn't know better. So we were just happy as ever because, at least we did have a place to go and play.
My name is Alvin Brooks, and I'm a former police officer here in Kansas City, Missouri. And in the summer of 1954, after the Swope Park swimming pool opened up, I was assigned out here for about maybe 5 weekends because of the riots in St. Louis and Pittsburgh. And
they did have trouble in St. Louis, and people went to the hospital, and it was a bad situation. And a year or so before the Swope Park case, and I'm sure it was in the backgrounds of people's thinking.
And the first day I came out, I introduced myself to a fellow that was over the physical education program, either Northeast or East, and we became very close.
African American guy?
No, we're no African Americans working out here. No. And so I told him why I was out here because of the riots. He looked a little shocked when he saw me.
Well, that's always been the basis of segregation, that we aren't as civilized as the white race is.
I'm Susan Lawrence, and I grew up in Kansas City. I remember when the pool was desegregated. It was very crowded with whites, and then after the lawsuit, the white people stopped going. And my family went. We were the only family in the pool, it felt like.
I would not call it particularly a success story other than legally, because the pool, in the long term, the pool, was opened on an integrated basis. The attendance did fall off rather drastically.
It was the Jim Crow, we didn't have Jim Crow laws, but it was a Jim Crow mentality. And it was in Kansas City.
Just so sinister. To look back over history is painful, but I just have to say, well, look at us now.
Judge Howard Sachs. And let me introduce our guest to you a little bit more formally here. Thurgood Marshall Jr. is a lawyer in Washington, D.C. Thurgood Marshall. That name rings a little bell. Are you with the Wisconsin Marshals by any chance? Thurgood Marshall, ladies and gentlemen, from Washington, D.C. Al Brooks is here. He's got more titles than the Boston Celtics. He's a former Kansas City police officer, a former Kansas City mayor pro tem. He's a current member of the Kansas City Board of Police Commissioners and founder of the Ad Hoc Group Against Crime. And those are only a small portion of the number of titles that Al Brooks holds. And from the UMKC Law School's Professor David Ochtenberg, he's done extensive research on the intersection between civil rights and American legal history. David Ochtenberg. Judge Howard Sachs served as a law clerk, as you heard in the video, to U.S. District Court Judge Elbert Ridge when Judge Ridge handled the Swope Park case back in the 1950s. Judge Sachs is a 37-year judge on the U.S. District Court for the Western District of Missouri. He worked with David Ochtenberg's father to integrate the Kansas City Bar Association back in 1955. And just a little factoid of note, he was in Tokyo Bay on September 2nd, 1945, aboard the USS South Dakota when the Japanese signed the terms of surrender ending the Second World War. Judge Howard Sachs. Well, Thurgood, let me begin with you, if I can. You know, your father worked obviously at the intersection of the law and the civil rights movement. I wonder if you can recall for us, you know, what memories you have of your dad talking about the early days of the movement and how he managed to be patient even though the law moved at such a plodding pace.
Well, what I've learned over the years and fitting that what I've learned in with what I was exposed to from my father has taught me that the patience that he and his team displayed was very much tied to the confidence they had in the architecture that was constructed for the lawyers working on the civil rights cases. That was something that his mentor, Professor Charles Hamilton Houston, had developed in the 20s and 30s. But the plan itself, if you think of it as a playbook plan, was something that sketched out a very careful sequence of cases and court rulings that spanned 30 or 40 years. And their faith in that plan is really the explanation for the kind of patience that they displayed through all of that.
You know, David Ochtenberg, in hindsight, I'm guessing this was an enormously exciting time in the history of American jurisprudence. Do I have that right?
Oh, yes. Sorry about that. No, there was a tremendous amount going on and I'm just thinking in terms of this area. There had been the desegregation of the swimming pool in St. Louis, and just ironically today I met with Judge Draper on the Missouri Supreme Court, and his father was one of the young people who integrated that pool, got arrested, and became the plaintiff in that case. Not long before this happened, 4 African-American golfers staged what I always thought is the perfect example of effective civil disobedience. Swope number 1 golf course, what we now think of Swope Memorial, was segregated, and they simply went there, put down their 75-cent greens fees, and said, we'd like to play. They said, you can't play. They went out and played. And the next week, they came back, put down their 75 cents, and just no one ever had the courage, the stupidity, to arrest them, so the course was integrated.
Judge Sachs, how big a deal was this Swope Park pool case at the time, back in the 1950s, in terms, you know, not only of its impact on the civil rights movement, but its impact on the fight for racial equality even larger than that?
At that time, the racial cases were going to the Supreme Court, were being decided, particularly graduate school cases, the right to attend college and schools, but there had been very little litigation on things like the right to go to swimming pools. It was very important in Kansas City because things were changing in Kansas City. Things were beginning to open up, but in a public sense, the schools, segregated schools, and the Swope Park swimming pool were the principal institutions that were closed, were divided between black and white youths. And so it was very important that things moved on the swimming pool, in the swimming pool area, which was a very controversial area.
Al Brooks, you were there. Describe, if you would, these two Kansas City pools to us that were in use back in the day. The whites-only Swope Park pool and the blacks-only Parade pool, which was at 17th and the Paseo. Do I have that right?
Yeah, that's right. Very separate and unequal. The Swope Park pool, of course, we could go out as black kids and watch the white kids swim. Beautiful landscaping and all around. The Parade Park bathhouse, as it was called, 17 Terrace Paseo, was a small building, and what we had to do after that was in the morning, finished bathing in the bathhouse part, then they let the kids in, but only so many. And so we had to stand in line all around the pool. There's no shade or anything like that. Stood in line, and then after they swam for about an hour or so, then they would empty the pool, rechlorinate it, and let another group in. And so some youngsters got very smart, and the sun was so hot, they would allow their trunks or their swimming suits to dry off, and they'd get back in the line. And so, of course, and I think you heard from Clarence, who was in the video, say that what would happen is they'd go around and feel the trunks and determine whether or not you'd been in before. But I think as a youngster coming up, you could see the difference. We didn't really know why, but we knew it was there. And so it's very different atmosphere and all. And in fact, Elvis Sennett Gibson, who I think is out here, who wrote he's a local historian, I just found out today, he and I were discussing this, that the city had given that bathhouse to black kids back in 1920. So the bathhouse that I experienced as a kid that was a new one. Now, I wasn't back there in 1920, but almost. But it was just different, completely different night and day.
How upset were African Americans at the time over all this? How much frustration was there?
Well, I think the frustration was there because all you need to do is to go out to Swope Park. Now, when you went out to Swope Park, you only had one place that you could go out there. It was called Watermelon Hill, Shelter House number 5. How many out there know about Shelter House number 5? Let me see the hands up there. Okay, thank you very much. So what happened was that we could go to the zoo and go to that Shelter House number 5. But if you ventured off into the other places, the park ranger would run you off with the horses. And then if you tried to cross the swinging bridge to go to the lagoon and the swimming pool, the white kids would fight you unless you were in pretty good size and pretty good sized group. So some folks in the smaller part of Little Blue River, because that's what the swimming pool, the swinging bridge was over, we'd walk across there. We didn't know it was as deep as it was though sometimes. But and we could not rent horses, we could not rent bicycles, and we couldn't rent boats in the lagoon. So those are the kinds of things that you, as growing up, you always wondered, why this out here at Swope Park, and why this? And see, we had to go through Confederate territory to get out to Swope Park from where we lived.
Wow. Thurgood, I want you to go back to your dad here, if you would. Can you give us a sense of at least what you know of your dad's life during the 50s and 60s as he traveled the country working on one case after another? He was the lead counsel on the Swope Park pool case, but he was juggling multiple lawsuits in those days all over the country, sort of like a juggler handling 9 balls. How crazy was his life back then?
Extremely. And having come along late in his life, it took my brother and I a while to realize that one of the great blessings of that was that had we been born when he was practicing law, we might not have seen him more than 30 or 40 days a year. There were times when he was gone for 270 or 280 days in a year. And to the point where one of my favorite photos of him, an author provided to me, and it's a picture of him on stage with Joe Louis and General Benjamin O. Davis, and the three of them were getting awards. And I thought this was wonderful, and they were wearing really dapper clothing. And the reason the reporter gave it to me was that the following day, my father ended up in the hospital for about 5 to 6 months because of exhaustion. And if you look at these take your eyes off the other two luminaries and off the clothing, you can see it in his face. It was a matter of everyone on those legal teams traveling the country, working the cases, appearing in court, but he was also raising the funds to support this process and building support in communities to make sure that the support would be there to resist the urge to resort to violence, and that the support would be there for the local council and for the parties in these cases, who, after all, were risking their livelihoods, their well-being, to be part of that effort.
Judge Sachs, at the time that you and Judge Ridge were working on this case, did you have a sense of how big a deal it was?
Yes, I did know it was an important case. It's the only case where I've kept my notes and a memorandum to the judge about the law and the facts during the period of my clerkship. And looking back, it seems clear to me that there were 3 cases locally that were the most important regarding race relations and civil rights. This was the first. The second one had to do with the ordinance that opened up restaurants, hotels, and motels, and that was challenged in the Missouri court, saying that Kansas City had no right to enact such an ordinance because the state had not moved on race relations. That was decided in favor of the Kansas City ordinance in the mid-60s. And the final case that everyone knows about, of course, is Judge Russell Clark's school case.
You know, Judge Sachs, Judge Ridge did something very interesting with the Swope Park pool case. After he had written his initial opinion, he asked some of his colleagues to review his 28-page opinion before he released it. And I'm wondering why and how unusual was that for him at the time?
It was extraordinary. I didn't, as a new law clerk, I didn't realize how extraordinary it was, but I've never seen anything like that since as a judge. He took the case and he spread out the sheets on a very long conference table in his chambers, and he had his colleague Judge Duncan from St. Joe, a federal judge from St. Joe, come down and look through the work, and he had the United States Attorney in, and I think he had the Marshal in looking through the opinion just before he had it signed and filed. And it was extremely unusual, and I think the principal issue was the fear that we would have something like happen in St. Louis, that we were looking at racial violence and perhaps even a riot once this decision went into effect.
You know, I'm not sure I'm going to ask this next one to either Al or Judge Sachs or David here. So there was this attempt by Esther Williams, as we heard, not the famous swimmer, but a dietitian at Kansas City General Hospital No. 2, and other African Americans to buy tickets to enter the pool. What do we know about that? I mean, was that an organized effort to begin to change the status quo? What do we know about that moment? Judge? Yeah. Now we all know something about it, yeah.
Checking through the dates, the lawyers from New York were coming through Kansas City to go out to Topeka for a conference on the, or maybe it was the beginning of the trial, in the Brown versus Board of Education case. And on the way out there, they stopped in Kansas City, obviously to consider a pre-planned test case. And on the same day, the plaintiffs went out to try to buy tickets and weren't able to buy tickets. So it was a case that was a test case that was worked through not only the local NAACP, but also the New York office.
David, I'm wondering how Kansas City officials back in the day justified maintaining these two different pools for people of two different races.
Short answer is badly. The basic justification was, one, we need to prevent violence. Well, of course, there's only violence in reaction. And the other was, I'm not going to quote this exactly, but the natural aversion of people of different groups of society to mingle. While we're on the subject of the sort of strategy here, the local lawyers involved in this case were Carl Johnson, who subsequently became the first African-American municipal judge in Kansas City. He'd been a NAACP president from the 40s, and then went on to be on the national board, and later became one of the four first African Americans in the Kansas City Metropolitan Bar. And there was also a young lawyer who worked with him, whose name was Almer Adair. And I mention that, first of all, because I've been trying to find out things about him for quite a while, and because two of his daughters and at least one of his grandchildren are here today. And I thought I'd mention that.
And David, this was hardly the only case in the country that was dealing with the integration of public pools. Give us a little context there.
Well, throughout the country, first of all, pools were special, and partly because they involved people of both genders in what then was thought of as being scantily dressed. You would not think of it as being scanty now. It was a very big hotspot in Jackson, Mississippi, when they were required to integrate the pools. They simply closed the pools, sold them to a private entity, and were still defending that in the 1970s. But you know, pools involved the big taboo, which was African Americans of one gender and whites of another gender. And this is an era when that was a major frontier. In fact, I remember the only time I heard Martin Luther King speak in person. I was in a gathering where he was asked the question, does this mean what you're talking about, that white men and black women can get married, or something like that, that interracial marriage was possible? And even Martin Luther King was not ready to break that, at least in this audience, and said, the white man wants to be your brother, not your brother-in-law. And so that, yes, you know, on the one hand, it's a swimming pool. On the other hand, it's a symbol of everything that was a caste system in this country. And I'll go on for one more. My great Aunt Molly, a wonderful woman, when she found out that the Barney Goodman camp was using the Swope pool to swim in, said to my mother, and I was there, something like, well, but you know what those, and I'll use the phrase she used, colored boys do in the pool. And I remember my mother saying something like, exactly what every other boy does in the pool.
Thurgood, you want to hop in?
Thanks, Steve.
Yeah.
I did want to add on this point of this case being early in the line of cases on public accommodations. To me, says, knowing what my father and his team's strategy was, that there were a number of factors that they considered. Being in Kansas City, home of the Royals, I have to tip my hat to the Royals, but it's very much, for those of you who are familiar with the book or the movie Moneyball, they had the legal version of Moneyball in play there. They were very selective about the cases that they chose to advance in the queue. They were very selective about the cases that they decided to slow walk in the queue because they wanted to build a specific progression of victories in each of the disciplines where they were pursuing their strategy. And what that included was an assessment of the local legal talent, the local legal community, and the NAACP's operation in a community. And it also included an assessment of the judges at the trial court level and the Court of Appeals level. I think in this case we've learned we should also have added law clerks, but
Yeah.
but it was very much an indication to me, since this case was early in the public accommodations line of cases, that the conclusion was made by that legal team that this legal community and the local community here had the strength of character to advance this and to address the repercussions that would come from it. And I was struck by that when I saw the references to the violence in St. Louis in the KCUR piece at the beginning. There were instances later in the 50s where, for example, Governor Faubus, who, as you may not know, in Arkansas was actually a very progressive governor until they tried to integrate Central High School there. There was violence, National Guard got called in, and in history, all of the work he did as a progressive governor is lost to him later being tagged as basically a George Wallace type governor. And so all of that factors in, particularly the strength of character in a community.
You know, I was really struck by the fact, Thurgood, that your father was in Kansas City to argue this case, but he wasn't in Topeka for Board of Education versus Topeka, at least early on. Do you know why that was?
I was struck by that too, and I have to say two things. And one is, I'm just going to reference by footnote everything I just said, and I'll do that in a moment. If he was not in Topeka, given that that case was really the crescendo in the line of education, the school cases, it must not have been a critical moment in the case, although there were other lawyers from his team in Topeka. But what is important to me about my father's presence here in Kansas City at that time is not so much that he was not in Topeka, but that he was nowhere else because of all the other cases going on. He had death penalty cases that he was handling at the time. He had so many cases, so many fundraising obligations that he didn't have the luxury of being able to just show up where needed. He had to strategically select each court appearance and each meeting.
Judge Sachs, what was Thurgood Marshall like in the courtroom?
He really was clearly the most impressive lawyer in the case. He took over. He had the lead. It was not a very demanding case. It was a one-day case, and most of the facts had been agreed upon at a pretrial conference. So the facts were not really very much in dispute, and the law. He was asking for a decision that segregation was in itself a violation of the Constitution, but at that time it was before the Supreme Court spoke. It was clear it was going to be decided on a separate but equal basis. So both the facts and the law were fairly clear, but he presented the evidence and cross-examined the city park board members very, very effectively, and it made both the city witnesses and the city lawyers look like a crabby old white man.
What was he, an intimidating man?
Was he what?
Intimidating.
Intimidating. He may have been at times. In this particular case, he didn't need to be very dramatic, but he was in control in the case. I might add that from things I've read about the school cases, that he was in I think the South Carolina. I think he took the lead in the South Carolina trial.
Maybe I should ask the son. Was Dad intimidating sometimes?
I never had to face him in court.
Al Brooks, to what extent was the black community sort of watching this case unfold? Was it like, were you reading about it in the papers? Was it a big deal or not?
Well, it was a big deal. I think also, if I might just back up just a little bit, I was a police cadet in the police academy. And I think the audience probably saw the photo. You probably couldn't pick me out. There were 29 in there were 29 in the class, and it was difficult to find me. I was the only one. But what happened when remember the pool, and I know that Judge Sachs will remember this, the pool opened and it closed because they had the riot in St. Louis and in Pittsburgh, and I know they had it in Detroit. And so the park board then closed it, even though I think the order had come out. But then they opened it again in 1954, and it's kind of interesting because, in June of 54, kind of interesting because at that same time, 17th of May 1954, Brown versus Board of Education. Both of these cases was based on the 14th Amendment, equal protection under the law. And I thought it was, it was already decided though, with Judge Ridge, with the law clerk, Howard Sachs at the time. But the community followed this. The Kansas City Call followed this, and I think Roy Wilkins might have been on one of the reporters at the time. But they followed this, and you look at the clippings, and if those who want to pick up a copy of Sonny Gibson's book, Sonny, if you're out there and you get some money, I want to know about this. But it showed at that time that they kept up with it, and so when the decision was handed down, it was news. It was certainly news in the African American community. But at the same time, there were those at the time in my parents and others in the earlier years were saying, well, if they don't want us now, we don't want to go then. And so you'd go out there, and I noticed the photo, it must have been that weekend of Labor Day that this photo was taken, because no other time when I was out there. Now, I said I was a cadet. When the order first came down, the pool first opened in June of 54, they had seen, I think all the police, in Kansas City were out there. But then it began to dwindle, and then I came in the last about month, and I was there over Labor Day 1954. But I was still in police academy. And my colleagues were fearful, and most of them were opposed to the desegregation because, well, they say because of the violence. I think it was based on racism, but they never said it, but you could tell from the conversation leading up to that it was more than just a matter of violence. But I think it was a lot of jubilation in terms of the order itself, but not in terms of, well, now we can go swim out of Swope.
Yeah. David or Judge Sachs, was there much suspense here, or was it sort of preordained how Judge Ridge was going to settle this case?
I think it was basically a fairly easy case to decide, although these cases could be, the way you analyze it, and if you have some bias, you can kind of work things around differently. But the issues that seemed pretty clear to me and seemed pretty clear to Judge Ridge also was the overcrowding that has already been referred to in the Parade Park pool. And the Court of Appeals was interested in the fact that people who were having a recreational activity out at Swope Park, which was described by the Court of Appeals as by far the most impressive recreational facility in the metropolitan area, the people who were going out there for picnicking and various other activities, if they were white, they could swim. If they were black, they had to travel 4 to 6 miles to the other pool. This was what apparently most impressed the Court of Appeals. But you can play around. The term was substantially equal, and the Court of Appeals did say that the Parade Park pool could be treated as an excellent pool, at least for a neighborhood, as a neighborhood pool. It was built in 1939, a WPA project in 1939. So it was not that obvious that you'd say it was substantially unequal.
And so finally, then, Judge, the ruling was what?
That it was not substantially equal basically for the two reasons: the one that Judge Ridge used of crowding, and the one that the Court of Appeals used about being forced to travel if you were having a outing at Swope Park. And then it went on up, it went to the Court of Appeals, and they tried to take it to the Supreme Court, and the Supreme Court would not consider it.
Al Brooks, on the day of the ruling, do you remember that day? Is that a day that stands out to you or not?
I don't remember that day. I don't remember it, Steve, but I share this. I noticed in the pleadings, and as I read the case, it also talked about the wading pool, which is 27th and Garfield, which was about as large as a stage. But the wading pool out at Swope was all, the wading pool, the diving pool, the swimming pool, and then also where you could go underground and watch people swim. Anyone, even as I read the case in defense that the city put up, and of course the judge was there, so poorly defended. I mean, how can, nowhere in the world they could defend that and in that whole situation. But one of the crucial points that was made by Chief Justice, not Chief Justice, but Justice Marshall, but when he was not Justice then, was, and he opens up, and I shared this earlier, and it's quoted in A. Leon Higginbotham's book, In a Matter of Color. He said, of all the multitudinous group of people in this nation, why do you have to treat Negroes differently? And that, I think, was what Douglas and others, Warren and all, and you remember that Chief Justice Vincent had died, and the case had to be retried. And so then that's when Eisenhower, who was opposed to desegregation, appointed Earl Warren governor, supposed to have been a conservative governor of California. And they say that after Eisenhower left office, there was a reception one time. And it said that one reporter said, well, President Eisenhower, of all of your appointments, which one was a mistake? And Earl Warren was in the crowd, and he pointed at Earl Warren, because Earl Warren was the one, and as I read through his memoirs, and he was saying that he would not bring this case up until he had all 9 affirmative votes. And he got them on the 17th of May, 1954.
Thurgood, do you have any sense of how your father reacted to this case? Anything in his writings or anything he talked about later? Or was this just one case in a string of cases at the time for him?
Not yet, and I can, this promise I will follow up on.
You're going to answer my question. Let's be clear about this.
I will.
Yeah.
I can guess how he reacted. From what we know about the way he proceeded, which was to seize upon the opportunity to build the next case, and I'm sure there were a number of fundraisers that followed immediately thereafter, because the ability to point to a victory like this and the way in which a community responded in measured fashion was a very helpful way for them to move forward and build cases. What was it that I promised to respond to?
Just any personal recollection you have of how he reacted to this case?
I was not. That's right.
I know you.
The judge from but my earlier visit, when I had the chance to learn about the case for the first time from Judge Sachs, prompted me to try to find information at my father's old offices at the Legal Defense Fund. It's taken a while, but we have documents coming. So we're going to have those answers,
Oh,
I
that's
think,
great.
in short order. We're at least going to have more information about the case from the Legal Defense Fund side, which should be fascinating.
Is there a book there?
What do you think, Jeff? I don't. He's our fearless leader. If he says
Yeah.
yes, we're on it.
Yeah, yeah. Al, you talked a little bit about this. Did whites and blacks then link arms and flock to the Swope Park pool to swim together in the wake of this? Or describe again a little bit more about what you found.
There weren't any arms to be locked. I mean, it was, as I say, most of the swimmers out there, when I was out there, those several weekends, I was out there only on the weekends. There a few whites were there, more spectators, as there were when in reverse. When black kids couldn't and adults could not swim, then the black kids were looking in, and when after the order came down, that most of the white kids would. And it's interesting too to see a number of the white kids came out with swimming trunks and suits, but their parents wouldn't let them go in, and which was very interesting. And I just talked this week with a young lady, and she thanked me for saying that. She said when she went out there to swim, and she said, I don't know why that I asked the question of my mother. She said, Mother, why aren't any Negroes out here? And she said she was 12 or 13 years old in high school. She just asked that question. But her mother never responded, she said. She just told me that this week.
Now, I've got some numbers here. Attendance for the Swope Park pool in '54 after the ruling reached about 48,000, and it was a hot summer. The relatively cool summer of 1950, 4 years before, had admissions of more than 90,000. So you begin to see the dramatic change in numbers, Al.
Well, and I would assume that after that, things began to change in terms of both black and white were swimming. But keep in mind that this was tied to the school desegregation case. And that was still, that didn't go easy, because the fall of 1955 was the first year that with all deliberate speed, as the Supreme Court has said, that desegregation, if you will, began to start. So you had one case, but now public accommodations that the judge mentioned didn't happen until 1964, 10 years later. So there were still restrictions in terms of where you could eat. And I'm old enough to remember, and some others might be, the only place that if you were African American could eat downtown was at Kraske's on the alley. And that was it. And I can remember as a kid going downtown. My mother allowed me to go downtown and pay the light bill at the 1330 Baltimore, and I would always love to stop and get one of those segregated hot dogs and segregated Cokes, and I didn't know what they were at the time. I didn't know. They taste pretty good to me, but then as I grew older, they didn't taste at all because I wouldn't go there. And so I think that all this tied in together. From 1954 to actually 1968, the Housing Act, the same group that came up with the referendum to reverse the city council decision on public accommodation was the same group that gathered enough signatures to put it as a referendum in 1968 on the housing. But we had the riot, and then under the leadership of Ike Davis in the city council, came in with an emergency measure that made the referendum null and void, and therefore under what do they call it, public welfare and safety of the city, health and welfare and safety of the city, it was passed without referendum. But all this tied in a matter of about 14 years.
Did Judge Ridge's ruling make national headlines? Do we know what the reaction was in the media? David or anybody?
There was a similar ruling in St. Louis. It was not all that major, except in Kansas City. It was a big situation here. But the federal judge in St. Louis also ruled for the plaintiffs, although he had a somewhat easier case because there were no outdoor pools in St. Louis that were open to blacks.
David, I'm wondering about the legacy of this case when it comes to, the development of private clubs in the Kansas City area, in other suburban parts of the country. In the Kansas City area, we had the old Leawood Country Club. It opened in 1954. The Meadowbrook Country Club opened in 1953. Were those a direct result of the integration of the Swope Park pool? Do you have a feel for that? Yeah, Judge Sachs, any feel for that?
I, I doubt it. I guess everybody knows that, you know, private or at least pools sponsored by clubs, at least to my experience, have pretty much taken over. I don't know that the Swope Park case was decisive, but probably a sense of let's have swimming with members of our club is a major factor.
David, yeah, go ahead, Al.
Because what happened is that Fairland Park, which was supposedly it was public, but public meaning white only. What happened there that its membership, not membership, but clientele picked up because so the white kids, parents wouldn't let them go to Swope Park because they sent them out to Fairland Park, and which was really overcrowded at the time. Now Fairland Park became one of the major targets after the public accommodation was passed in 1964. The city ends and all of that, and in fact, eventually it turned out to be a private club like you have reference to, but whites only. You have to have membership. But I was a part of a group, a subversive group called the Congress of Racial Equality, and what happened is that we tested that and got arrested. I didn't get arrested at the time. In fact, I was on the police department at the time, and my wife got arrested, which didn't go over too well with the police. But I left that same year. But Fairland Park became the center of attraction for whites in this metropolitan area. One other thing, and Clarence Shirley was shared this with you. I don't know whether he shared it in the video, but there were no swimming facilities for the kids on the Kansas side, so the kids on the Kansas side also came to Kansas City, Missouri to swim. So that's why you had that overcrowdedness again.
You know, David, I'm wondering about another fight in this town, which your father, Irving Ochtenberg, who was a practicing lawyer and a contemporary of Judge Sachs, was involved in. He and Judge Sachs worked to end race and gender discrimination in the Kansas City Bar Association. Can you give me a brief history of that and how tough that fight was?
It's hard for me to do a brief history of it, but I'll try. It has an important connection here. In fact, that Judge Sachs, my father, Lyman Field, a number of other lawyers. Interestingly,
The leader, how was Irving Ochtenberg?
Interestingly, something that hasn't come up yet is the city attorney in the swimming pool desegregation case moved to disqualify Thurgood Marshall as a lawyer to appear to pro hac vice for purposes of the case, because he had belonged to the National Lawyers Guild, which they said was a communist front organization. Judge Ridge, as I understood it, said, if the Supreme Court thinks he's good enough for them, he's good enough for me. But an interesting sort of side thing here. One of the lawyers who signed that motion and who defended the city was a lawyer named John Cosgrove. He was an assistant city attorney. He signed the motion attacking all of that. 4 years later, his son and law partner, William Cosgrove, was one of the group of lawyers who worked very hard and successfully to desegregate the Kansas City Metropolitan Bar Association. So generations change, times change, things get better.
Judge Sachs, maybe just a final thing before we open it up to your questions in the audience here. How about the impact of this ruling on the burgeoning civil rights movement here in Kansas City, on other fights to end discrimination in public facilities?
Well, these things build on each other. When people get educated to the point that they know that people have a right to buy tickets to go to the swimming pool, it's helpful to the next stage where people have a right to go to a restaurant and be served. there is a difference, obviously, between a public governmental facility and a privately owned facility, but the privately owned facility supposedly is open to the public. That's why we call it public accommodation. So these things build on each other, and I remember that it was, I think, 1956 that the efforts to open up restaurants began.
Well, before we go to questions, we have a quick presentation here from Jeff Simon and Judge David Kays. Gentlemen.
Thank you, Steve. My name is Jeff Simon. I serve on the Federal Courts Historical Society. I'm sorry, are we good? I serve on the Federal Court Historical Society, which the purpose of which is to preserve and publish, discuss some of the more important cases and people who have come through that federal court over the years. It was founded about 25 years ago, and for all that time has really been, the heart and soul of it has been Howard Sachs, who, in addition to being the champion of civil rights, both as a law clerk and in drafting ordinances and in integrating bar associations, is also a well-known history buff. And the reason we are all here tonight is because about a year ago, Howard Sachs made the Historical Society aware of this case, and even more importantly, that he still has, from 1952, the original draft that he presented to Judge Ridge in 1952 that eventually became the order that we've all been hearing about tonight and that had such a profound effect on Kansas City. This is living history. This is how change happens. And let me tell you, when I asked him right before we came down here if I could borrow it, he was very nervous about turning it over to me. And so the court, recognizing what Judge Sachs is and his love of history and what he's meant, Chief Judge Kays is here, Judge Sachs, to make an announcement. Chief Judge?
Thank you. Well, I have the privilege of working around approximately 20 judges. And I list them, they're district judges, senior district judges, bankruptcy judges, magistrate judges, court of appeals judges. We're known as an independent judicial branch, which means we don't agree on a lot of things. But we do agree on one important thing. Judge Howard Sachs is a treasure to our number. And Judge Sachs has contributed in so many important ways, not only to our community, but to our court. And we're thankful that Paul Donnelly, Larry Rouse, and Jeff Simon, and many others have made this suggestion to the court. Let me read it to you, if you'll please indulge me for just a moment. United States District Court for the Western District of Missouri, resolution. Whereas Howard F. Sachs has faithfully and honorably served this court with distinction for nearly 40 years. First as a law clerk to the Honorable Albert A. Ridge, 1950 to 1951, and then as a district judge continuously since 1979. And whereas Howard F. Sachs has been both a student of and an active participant in the life and times of this court for nearly 6 decades. And whereas Howard F. Sachs was a founding member of the Court's Historical Society in 1988, and whereas since that time Howard F. Sachs, through his many relationships in both the academic and legal communities, has been the individual most responsible for envisioning the mission of and sustaining interest in the Historical Society. And whereas Lawrence H. Larson, the author of the district's published history, Federal Justice in Western Missouri, referred to Howard Sachs in the foreword of that work as an accomplished historian in his own right, who played a pivotal role in each and every phase of the development of his work on the court's history. And whereas Howard F. Sachs worked tirelessly with his judicial colleagues on first conceiving of and then collaborating on the development of much of the content in the United States District Court's Bellroom Historical Gallery, and whereas the history of this court, as reflected in the oral biographies of many of its judges, the published history of the court from statehood to 1961, and the historical display housed on the second floor of the courthouse, would not have been shared but for his vision and his efforts. And whereas the Board of Directors of this court's Historical Society has petitioned this court to recognize and memorialize these singular contributions of Howard F. Sachs, a distinguished judge of this court and a valued colleague of each member of the court en banc, now therefore be it resolved by the court en banc of the United States District Court for the Western District of Missouri that henceforth from this date the official name of the district's Historical Society shall be, and it is hereby, Historical Society of the United States Courts in the Eighth Circuit, Howard F. Sachs Branch, Western District of Missouri.
This is certainly a big surprise, a welcome surprise, and I didn't vote on that motion. And I do want to say something else about my draft. My draft is 7 pages long, and Judge Ridge's opinion is 28 pages long. So while I may have helped Judge Ridge in that sense, he did the work himself.
Steve, something else that Judge Sachs did not mention. In his draft, or to the court, the Negro was spelled with a small n. And Judge Sachs and I go back to the 70s when we were talking about civil rights together on panels. So forgive me if I say Howard, but I mean, all due respect, Judge Sachs. So the judge capitalized the n. And Judge Ridge asked him, is this supposed to be a capital N? And the judge said yes, and for henceforth and forevermore, it was a capital N.
The city briefing was lowercase, and the plaintiff's briefing was capital N. The city briefing, I hear people, unhappy about that. It was common usage, shouldn't have been, I guess, but it was common usage on the Supreme Court and elsewhere to use the lowercase until I think it's the late 1940s.
Well, we've got a few minutes for questions, so if you have one, please come down to one of the microphones we have set up in front. And while we're waiting here, I should point out that this event has been sponsored this evening by KCUR Public Radio, the Federal Court Historical Society of Western Missouri, and the Urban League of Kansas City. And finally, I just want to point out a little something to put on your calendars going forth, that on Tuesday, April 5th, NPR's Michelle Martin, weekend host of All Things Considered, will be at the Gem Theater to host an event. Michelle Martin going there, How We Eat, a conversation about what makes food good for individuals, for the community, for the environment, and who gets to take part. NPR, KCUR 89.3 are partnering to create this live stage conversation. Just watch kcur.org for more details of this event coming up on Tuesday, April 5th. Go ahead. Morning.
Yes, I appreciate this opportunity to see the son of Thurgood Marshall. I'm originally from Nashville, Tennessee, and I grew up during the Jim Crow era, and I felt that your father was a voice in the wilderness. He had such wisdom, and so my question to you, sir, is if he were here today, how would he advise President Obama in dealing with the Supreme Court?
Good luck.
Well, I love that question, and Nashville is a special place in the Marshall family. Here's another question dodge for you, Steve. My father had a cousin, Avon Williams, who was a state senator who was living in Nashville for many years. Had more than a few rocks thrown through his windows and crosses burned on his lawn, and fight in Nashville, and would love to visit there and visit family. So that's not provided me with enough time to formulate a good response to your question, but I hope you'll appreciate that. So I certainly think he would have wanted the president to nominate someone promptly and do everything he could to get a hearing before the committee. My father had the worst no vote in at least up to his confirmation in history, which was about 30 no votes in the Senate. He also was delayed on appointment to the Second Circuit in New York because of one senator from Mississippi. So I think part of the lesson from that is he would have wanted this to move forward quickly. But I'm sorry, Steve, let me add one thing. I know that as someone who appreciated Justice Scalia as a colleague, he would have been appalled that there was not the level of respect and tributes to a member of that court during those first couple of days after he passed away.
Right. Thank you.
Well, first of all, I wanted to say thank you and to congratulate Judge Sachs. Very well deserved. So I have two questions, but there are other people who have questions, so I'll just pick one of mine. I think it was the video that started off, or maybe it was one of the people on the panel saying that the story of the swimming pools isn't necessarily a success story. And I wanted to ask if you think that kind of civil rights is a success story. I mean, we have the desegregation of Swope Park Pool, but if you go to Swope Park Pool today, it's black. We do the desegregation of schools, but now schools are resegregated essentially. We have white flight, we have the truced wall, we have all these other things. So, like, what is the success story of the civil rights movement?
Say that again. Your mic wasn't
Oh,
on.
we haven't solved our problems. We've got a lot to do.
Success isn't a place, it's a journey. We're not at the end of the journey, and we probably won't be in my life, and probably not in yours either, but it's a journey, and it's easy to not realize how much things have changed unless you think about cases like this. And yes, there is segregation in schools, but believe it or not, there is integration in some schools, and that's a whole lot more than there was in 1954. And that's true, I think, throughout, that we're making progress, we need to make more.
And also, as you raised that question, I think that I'm concerned about the climate that we're in now politically. 3 or 4 months ago, I had an opportunity to sit in on a forum where the daughter of George Wallace and the daughter of Abernathy were on this panel. And it's one thing that the daughter of Wallace said that really brought tears to my eyes. She said, "My dad never sick dogs on black people, never beat them at billy club, never put fire hoses on them, but he set the climate for others to do it." And that's what I'm afraid of today, that the climate's being set politically, nationally, that causes when I don't care whether you're a Democrat, Republican, Independent, or Vegetarian, I think I got to say this. I got to say, it's because I think the climate's being set in such a way by some of those who are aspiring to be the president of these United States that bothers me when we go to the kind of things we're saying. I think it lends to what African Americans have experienced, which we still experience to some degree, but other persons of color coming into these borders. I think they forget about the lady that stands in the harbor, that holds the turned torch in one hand, the decoration pennant, beckoning people to come to these temperate shores. We hold, those kind of things. And I think that we've come a long way, but we've got a long way to go.
It's a good question.
Thank you.
I'd like to thank you all for this talk. And my question actually really follows up really well to what she was talking about. When we think about the civil rights movement, we often think about the role that the courts played, but obviously racism isn't over. And I was curious what you all think is the role of the courts now in doing anti-racism work, as well as the limitations of using the courts to do so.
Don't all jump at once.
Well, I'll start, I guess. The courts only get to deal with the cases that are brought to them, and that limits their role. It's better, at least in my view, if they decide the cases a little differently than the Supreme Court has decided them in recent years. I think it would have made a tremendous difference, for example, in the right to vote, if the court hadn't struck down the Voting Rights Act. So the court's role is to deal with the cases that come to it, but I hope they deal with it in a way that is more aware of the history of this country and the distance we still need to go, as opposed to thinking, we're done, we don't need to worry about it anymore, which I think is part of what some of the decisions recently have suggested.
Anybody else on that one? Okay.
Thank you.
Yes, sir.
Yeah, I wanted to give a success story on the pool. I guess it was the early 1990s. I had gone to York, Pennsylvania. While I was there, I was speaking for something. They were giving me a tour around the town, and they took me to their pool, and they had all black lifeguards. And in Kansas City, they were paying about $15 an hour to get white youth to come over and be lifeguards at all the inner city pools. So I came back, I was doing a summer tenureship with the Full Employment Council, and I got with Lee Swinton. And we went to different places, because up until that point, our kids were just playing in the pools. So we went to Grandview, we went to Overland Park, and we went to all these different places. So how do you train your kids? And so we found how to train them, and then we started training them in Central High School. And within a year, the pools went from being 10% black lifeguards to 90% black lifeguards. And these kids were kids in our community who were now taking leadership and earning a good pay, because they couldn't reduce the pay once our kids started being lifeguards. $15 an hour.
I don't have a question, but I have a comment. I'm a product of Central High School. I'm a practicing dentist in the Kansas City, Missouri area. I went to school with Mr. Brooks' son. He and I were classmates at Central. But I'm a product of that area. I actually remember going to Swope Park swimming pool. I'm telling my age now. I was born in 51. In 1954, never had any problems. I went to the wading pool. I was a little fellow, but I remember that era very well. My mom worked she was an RN at General Hospital No. 2, and I remember Kraske's. I had one of those, and of course then they weren't called hot dogs, they were called Frankfurters. But I even remember upstairs, maybe 6, 7 years old, my dad gave me 15 cents. And upstairs, black folk couldn't eat upstairs, but they had the little circular cafeteria. Dumb little old kid, I went there and sit. I had 15 cents in my pocket, and I wanted a grilled cheese sandwich. and the woman actually waited on me. Just a comment.
Yes, sir.
I'm happy to be here on this historical event today. Thank you for Jeff Simon inviting me, and the distinguished panel is just touching my heart hearing this. I mean, Alvin Brooks go way back. You can either get bitter or better. But I'm almost 65. I've seen history unfolding before my eyes, King getting killed and John F. Kennedy. But it motivated me to run. I'm the runner. I'm undercover tonight, but a KC Superman. But I run with all this in my heart and my mind. And, you know, I've been shot at myself, I've been stabbed, been beat up, been thrown in jail for the gospel's sake. But stuff like this historical, we can take this history. We got a man, either can get bitter or better. We all God's people, and I'm just happy to be here. And all this I'm seeing, like I remember Swope Park, I remember all this, but it's made me better. So I'm just happy to be here today to experience this historical event. Thank you.
Yes, sir.
My question is for Attorney Marshall. I'm afraid I have two and I have to ask you both of them.
Go quick.
Okay, they'll be quick and short. Okay, referring to Justice Marshall. Because President Bill Clinton referred to Justice Marshall as a great man, and that every American should be grateful for the contributions he made as an advocate and justice of the United States United States Supreme Court. Was there any interaction between you and your dad outside of the court system? That's the first question. Second question is, did Justice Marshall in any way seek vengeance against the University of Maryland, who denied him entrance to an all-white law school because of his race?
Thank you very much for the question. So most of my interactions with my father were outside the legal realm. I used to visit him at the court quite a bit, but more to spend time with him and not to talk about the court cases. University of Maryland, I love this question because one of the first cases he did was to second chair a case with his professor and dean and mentor, Charles Hamilton Houston, and they represented Donald Murray when he sued to get into the University of Maryland Law School. So I think I would not call that an act of vengeance, but I think he won the battle.
We got time for two more. Go ahead.
I just wanted to offer a ray of hope. I think that where the change is happening on a micro level, I have two grandsons that go to a school, and after Martin Luther King Day, they both came home on separate occasions with me. One of them so animated. Now they're 6 and 7, and he jumped to his feet and he started spouting off. And Martin Luther King said this, and Martin Luther, and he went on. I was so impressed. I mean, I was moved to tears almost because they were so. I mean, they're repeating what he had to say. They saw him as a true American hero that he is, an American hero for all of us. The other one went to a reading program. My son and daughter-in-law told me with great pride how they were asked at this reading program after school. Can anybody give me an example of cause and effect? This is the other grandson. He said, well, when Rosa Parks stayed on the bus, other people stopped riding the bus. And that, I don't remember the exact words of in his little, as a 7-year-old, but that made an impression. That he held on to that, and that's what he chose to give as an example of cause and effect. That's where we're going to see change, when our school systems continue to oppress upon our children what really is worth knowing. So, just
thank you. Ma'am, you have the last question.
It's not a question. I want to thank you. I'm about to tell my age. I was born in 41. The first job I ever had was with Parks and Recreation. Not many of us got hired. They processed us so much till they put my race down as white, because black kids couldn't get a job. I worked at Paseo Pool. when you couldn't swim at Swope Park, we had to go out there and work in the basket room. So I want to thank you. We couldn't go to Fairland Park, but one thing I think that we forget, Missouri is a southern state. And the biggest problem that we have today, that integration is a multicolor of immigrants, and people are trying to change the colors. And so I thank you, because had you not done what you did, then I would not have been able to go to an integrated school. I would not have been able, of course, I didn't send my kids to Swope Park or Fairland Park because they weren't nice to me, but however, my grandchildren can go. So I want to thank you for the efforts that you put forth.
Well, I think I can speak for all of us here. This has been an extraordinary evening with an extraordinary panel. Let's all say thank you to Professor David Ochtenberg, Judge Howard Sachs, Thurgood Marshall Jr., and Al Brooks. You bet.